Welcome everyone to Courtside, a discussion of legal issues. I missed last week because we were still in the Chauvin trial, and I can't talk about the trial substantively as we have an expected appeal and Chauvin's going to be sentenced, and there's of course the trial of the other three cops. But I did want to offer some personal reflections because to say that this super intense trial has been the experience of a lifetime is an understatement. And chief among it is because I got to work with the most incredible lawyers and people. I can't tell you how great they were. In the Hamilton play, Lin-Miranda talks about the divine providence that led certain people to be together at a certain moment in time at the founding. And I have to say I felt that way too. We were led by Keith Ellison, the first Black Attorney General of Minnesota. But the thing about Keith is, I thought he was a politician. I hadn't realized he was a darn good trial lawyer. And he understands juries, he understands civil rights, he understands the rules of evidence, he knows how to make a case. And we were so lucky to have that in the Attorney Generalship. Now, you saw some of our great courtroom lawyers on TV, people like Jerry Blackwell, Steve Schleicher, Matt Frank, Aaron Eldridge. Incredible, incredible. As good trial lawyers as I've ever seen. Jerry and Steve drawn from private practice, Matt and Aaron drawn from the government, just incredible. And Matt and Aaron and the other state lawyers who I'll mention in a moment just remind me of like every time when I went in to the government, you'd meet these lawyers who've spent their lives there and they have so much skill and expertise, and that's what I saw. So, the state lawyers were just so good. There were also others from the local and state, people like Josh Larson, Zuri Balkamid, Natasha Robinson, and Jean Burdoff. And then from my team, my team stepped up to the plate. Sandeep Iyer, who you might have seen on TV arguing some of the motions, Nathaniel Zelensky, Harrison Kilgore, Daniel Stempel, Victoria Joseph, Kirti Datla. And then there were just phenomenal other private practice lawyers, people like Lola Velasquez-Elgulo, Kerry Gordon, and Tony Atwell, chief among them. And maybe most importantly of all, the lovely Floyd family. I can't tell you their dignity, resilience, and strength. I found it hard to watch that videotape over and over again during the trial. I can't imagine what it was like to watch your family member have that happen over and watch it over and over again. All of us knew how hard this case was going to be. Cops aren't prosecuted for murder, let alone convicted of it. I grew up during the Rodney King riots. I saw what happened. We were all aware of the stakes here, every one of us, and no one left a stone unturned. And I've had the fortune of working on some of the most consequential legal cases in our lifetimes: the Voting Rights Act, the Affordable Care Act, Guantanamo, the Muslim travel ban. I've never worked with a better team or a more ego-friendly team. It was one mission and one mission only: to win this thing and to do justice. And the country is better for it. Derek Chauvin is the first cop to be convicted of second-degree murder in Minnesota history. And we can use this as a lesson. Let it not be a one-off. Let it be the springboard to future reform, future thinking, future conversations. I just read that Newark, New Jersey last year, the cops in Newark didn't fire a single shot, not a single bullet, not one. Now, I don't know if you've been to Newark, but it is not Princeton, New Jersey, and yet they were able to accomplish that. That tells you something about our future. Now, I want to change topics and spend today talking about a tragic decision by the Supreme Court this week. It involves juvenile life without parole. The United States is literally the only country that permits youth to be sentenced without possibility of parole. It's considered a violation of international law. Article 37 of the Convention of the Rights of the Child reads, quote, "Neither capital punishment nor life imprisonment without the possibility of release shall be imposed for offenses committed by persons below 18 years of age." But in the United States, each year, children as young as 13, when they commit their crimes, are sentenced to spend the rest of their life in prison with no opportunity for release. About 2,500 children are currently sentenced to life without parole in the United States. Now, states have been reforming their laws a bit in a good direction. 32 states have updated their laws since 2012, but 26 states still allow life without parole for juveniles in one way or another as an option. The Supreme Court has been, pretty active in this area. In 2005, in a case called Roper versus Simmons, the Supreme Court said that juveniles couldn't be sentenced to death. In 2010, in a case called Graham versus Florida, the court banned life without parole for juveniles who haven't committed homicide. And then in 2012, in Miller versus Alabama and Jackson versus Hobbs, the court held that mandatory life without parole sentences violated the Eighth Amendment. Justice Kagan's opinion wrote that judges must evaluate the personal characteristics of juvenile defendants in order to provide a fair and individualized sentence. As she put it, adolescents experience, quote, transient rashness, proclivity for risk, and inability to assess consequences. Four justices, Justices Scalia, Thomas, Alito, and Chief Justice Roberts, dissented. They disagreed, saying that the majority didn't sufficiently characterize juvenile life without parole as cruel and unusual. Now, the case before the court that was decided last week was called Jones versus Mississippi. Brett Jones committed his crimes when he was 15. He had stabbed his grandfather. He was sentenced when he was 26 years old. At the time of his sentencing, he said he was a different person. Now, in Mississippi, where he was sentenced, there isn't any finding of permanent incorrigibility that's required. You can put someone in jail for life, a youth, even if there is no finding that the person is likely to commit crimes again in the future. And in Jones's case, there was all sorts of testimony, including from Jones himself, that he had reformed and rehabilitated, and the Mississippi court said that doesn't matter. Now, Jones then challenged that and said, no, look, the Constitution requires some individualized consideration. Am I incorrigible, or is there some chance that I'm rehabilitated and could be sentenced to life with the possibility of parole? The Supreme Court, just a few days ago, in an opinion written by Justice Brett Kavanaugh, rejected this other Brett Jones's claim, 6-3. The Supreme Court said you don't need to find incorrigibility, that they aren't necessarily blessing the practice of juvenile life without parole, but the Constitution doesn't require something different. Justice Sotomayor wrote a biting dissent. She was obviously having none of it. She accused the majority of turning its back on the law, turning its back on precedent, citing a whole bunch of opinions by Justice Kavanaugh about the importance of adhering to precedent. So now we stand alone in the world. The United States is alone, and in defiance of international law, and frankly, in defiance of good common sense. We now, whoop-de-doo, have the ability to put people in jail for the rest of their lives for something they did when they were 15, even when they could be rehabilitated. That's inhumane, it's wrong, and it's stupid to boot. And if you're outraged, there is something you can do about it. Remember that the Supreme Court only said that this regime was constitutionally permissible, not that it's required. So if you're in one of these states like Mississippi that permits this practice, or frankly, you're in one of the other 26 states that permit it in some way, shape, or form, juvenile life without parole sentences, write to your legislator. You can make a difference. Do it. These laws have to end. I'll see you next week.